following is a paid program. Advice and opinions expressed during the program are solely that of Melick Law, not WBEV or Good Karma Brands.
Daily Dodge TV. Forgot I was there, Rob Melick. How you doing?
I'm doing well. How are you?
No, like, see what I did last time was telling you the hires. I forgot to turn I'm new engineering the Daily Dodge TV part of this thing.
Sure.
And then I was like, do I have the audio on or not? So I had to look over there. I'm like, yes. And I didn't say we were on 1430 ESPN Beaver Dam either.
Yeah.
So
we're ready to go.
we could talk sports though, because we talk a lot of sports. We're both in the midst of hockey season right now.
I could talk sports all day long, but I think people are here for other things.
Exactly.
Sprinkle that in as well.
Exactly. Melick Law, and I guess before we get going, tell us the basics about what you do and where you're located.
Yeah, so I'm an estate planning attorney. I do basically anything related to those end-of-life decisions that people don't want to think about but know that it's probably important that they ought to do, whether it's powers of attorney, wills, trusts, probate. That's what I help people navigate, and obviously it's called estate planning for a reason. The goal is to have a plan in place so that we're not reacting to life events, that we're actually planning for these inevitable events, and that's what I help people do, whether it's reviewing existing documents that people have in place or starting from scratch. I am able to help people in either of those situations. So I do have 4 office locations. For most people in the viewing and listening audience here, my Beaver Dam location is probably the most proximate. Sandy and Matt let me use their office over at the Heritage Hills Mall, but I do also have offices in Richfield, West Bend, and I have one in Port Washington, but that's soon going to change to Saukville. I bought an office building in Saukville, so that'll be open starting December 2nd. So if you want to travel out to the Lake Michigan part of the state, I have an office out there as well. Things about my practice that I think are relatively unique is first is I always offer free initial consultations. I've learned in my practice that there's enough barriers to getting people to come meet with an estate planning attorney that the cost of the initial consultation should not be one of them. So it's always a free initial consultation. And then also I do offer a 20% discount for WBEV listeners or Daily Dodge subscribers. So if that's how you heard about my platform and you want to learn more about estate planning, mention those, and we'll happily take 20% off the bill for you.
As we go along today as well, if you do have any questions as we talk about different topics today, you can give us a call at 920-885-4446 or 920-887-9595 is the text line. It's 920-887-9595. If you want to send a text and you don't want to call, we'll gladly take that text and answer the question. I mean, where do you want to start today, Rob? I mean, we talked about a lot of different things, and I know last time we were on, we really hit on, I think it was estate planning. I think we really touched on. One of the other things, if people go to your Melick Law site, melicklawwi.com, they can find a lot about you. But you have one thing that's labeled on there is elder law. Can you describe kind of what elder law, would you define what that means first?
Sure. So estate planning kind of just has a general overview to it. As a practical matter, most people, certainly not all, but most people kind of put it off until they reach their elder years. Now, age is relative, you know. I forget the cliche, I'm probably going to get it wrong, but, 60 is the new 40 or whatever people say in that regard. People are living longer, they're living healthier. But I just wanted to kind of carve that out as just an explanation for the fact that my practice does mostly involve, let's say, people over the age of 55 or 60. Now, that's not to the exclusion of other people, of course. Obviously, the longer you have an estate plan in place, the more you get to enjoy the peace of mind that comes with having a correct estate plan, knowing that the money you worked hard for during your life goes to the people or the causes you want it to go to with as minimal cost, time, aggravation, and governmental interference as possible. I mean, that's my practice in a nutshell, making sure that that time, cost, delay, and governmental aggravation portion go away because we have a proper and thorough and well-thought-out estate plan in place.
We're talking with Rob Melick from Melick Law again, and a lot of things going on. You talk about, and we've always talked about, people think, needing wills or trusts. It's older people. That's not the case. It should really start. We always have made many talks about this, that if you're 18 years old, it's good to have something in place in some capacity, because there you're on your own when it comes to being able to make legal decisions, unless there's things that are written down on paper allowing other people to make those decisions.
Absolutely. 18 is a hallmark age. I mean, it is the age at which somebody reaches the age of majority, and it's something I talk about a lot on the show because it's something that a lot of people aren't aware of. I mean, most people know 18 is the age of majority, but they don't understand the estate planning ramifications that come with becoming an 18-year-old. So I tend to focus on these shows about those areas of the law. I mean, again, most people generally know, hey, having an estate plan is a good thing. Making sure your wishes are going to where you want them to go, generally a good thing. But when it comes to that 18-year-old, a lot of people will roll their eyes and say, well, what does an 18-year-old need an estate plan for? Well, I'm going to articulate why an 18-year-old needs an estate plan. Specifically, once that person reaches the age of 18, they are now subject to what are called HIPAA regulations. I'm sure most people have heard of HIPAA before. HIPAA stands for the Health Insurance Portability and Accountability Act. In English, it determines when and under what circumstances medical providers can share your medical information. Now, if you or I go to our physician and we share information, obviously we do so with the goal of trying to get better, trying to improve our health, whatever the case is. And it's a good thing that that information is not shared. I don't want that information being public record. I want to be able to confide in my physician and share information that I don't necessarily want the public to know. The problem is that's not the only extent of HIPAA. HIPAA also determines when and under what circumstances that information can be shared. And the problem is that if we don't have an affirmative declaration that we want that information shared, medical professionals cannot share it. So the example I give is this. Let's take a random, just-turned 18-year-old in the state of Wisconsin. I'm going to state some facts about that person. First of all, it is very likely, though not guaranteed, that that person is still in high school. Most people in Wisconsin, once they reach the age of 18, are still somewhere in their senior year in high school. Okay, so whether it's just starting out the year, ending out the year, whatever the case is, they celebrate their 18th birthday while still a senior in high school. Most seniors in high school are living with their parents or guardians at that point. Sure, some are emancipated, maybe some are in the military, some are married, whatever the case is, but the overwhelming majority of 18-year-olds in Wisconsin, one, are high school students, and two, live with their parents. Third issue is that most of them are still on their parents' insurance plans. Most 18-year-olds don't have their own health insurance plans. So those three facts exist. They're in high school, they're living at home, they're on their parents' insurance. If that 18-year-old is involved in some sort of horrific accident, let's say a car accident, where they lose the ability to receive information, I think most people would assume, well, of course the parents can make medical decisions. Of course they can find out information. That 18-year-old is in high school, living at home. Well, those people would be wrong. They're not legally correct, because once that person reaches the age of 18, unless that 18-year-old has affirmatively signed a document saying, I want my parents to be able to make those decisions and receive that information, parents receive nothing. Now, I know we've talked before about having children, right? Our children are under the age of 18 now, but eventually they'll, hopefully, God willing, get over the age of 18. And once they have that magic moment over the age of 18, unless they have a estate plan in place, we're not going to be able to receive that information. We're not going to be able to make those decisions. And as a parent, that's got to be terrifying. And what I would argue is maybe there are some people in the listening audience who don't have children under the age of 18, but you may have grandchildren who are nearing that age of 18. And that's something that your children really ought to be aware of. If they have a young adult or someone who is going to be 18 in the near future, making sure that they understand that, look, without having these documents in place, parents can't make those decisions and receive the information. Receiving the information is almost the more important part.
Yeah.
You know, making decisions is one thing, but being able to find out what happened to your child, that can't be done without a power of attorney. Now, to be clear, this only impacts situations where someone loses capacity. The example would be if that 18-year-old is in that same car accident, and rather than becoming incapacitated by being in a coma, they break their leg. Well, sure, they're in pain at that point when they break their leg, but they can articulate, hey, call my mom, call my dad, do those things. That's fine. As long as they can articulate who they want to call, hospitals can do that. But if a person cannot communicate that information, as in they're in a coma, for instance, then they don't have that ability. And then the hospitals can't just assume that they want their parents to know that information. So again, what I always boil down to is math and statistics. The likelihood of this event occurring is very low, and that's a good thing. We don't want our 18-year-olds to be subjected to these types of unfortunate injuries. But here's the unfortunate reality. It's not a 0% chance either.
Sure.
It is somewhere north of 0%. I'm not an actuary. I'm not a statistician. I don't know what the exact numbers are, but I know they're not zero. So having this planning in place gives parents the peace of mind of knowing, hey, if their young adult is in that situation, we're not only going to be able to make decisions for them, we're going to be able to receive full and complete information regarding their care.
How complex is that document? If those are parents listening right now, they have a senior, maybe they have somebody that's a freshman in college that's 18. You're like, we maybe think about doing this, getting this done. How complex of a document is that to put together if they end up with an appointment with you at Melick Law?
Very easy. 5 to 10 minutes worth of information, 5 to 10 minutes to sign the document, it's in place.
Okay, so then it's in place, and then you have it, and we always talk about then you give a copy to whoever you're working with, and you usually keep them on file just in case somewhere at Melick Law?
That's right. And what I can tell you is this, because I get this question quite a bit. A lot of people just assume that their attorneys keep copies of documents. To be crystal clear, attorneys are not required to keep copies of clients' documents. I do it as a courtesy to my clients just because people make that assumption, and I have
Sure.
a cloud-based system where I can do it easily and relatively inexpensively. On the other hand, if I was, let's say, 20, 25 years older, before the cloud came into popularity and whatever the case is, I'd have to have boxes on boxes of client documents. That would just be unrealistic. But now with a couple clicks of the button, it's up in the cloud. So yes, I do keep copies of it. What I normally do for my clients is I give my clients the original in a copy set, and then I keep a digital copy there as well. That way, if it's lost or misplaced, I can easily retrieve it and print out another copy or scan and email it over to the client.
We're talking with Rob Melick from Melick Law. If you have a question, you can send us a text at 920-887-9595, because I believe that's probably something that people don't really think about very often. Like I said, I have 14-year-olds and a 15-year-old, and soon to be 16 and 15s, and you don't think about that very often. If okay, what if something happens to them? You just assume that it's going to happen, and you can take care of that with a 10-minute meeting and know that you're going to be set in case, obviously, God forbid, something would happen.
Yeah, and I think for whatever reason, the estate planning field is one that is just rife with misconceptions. I mean, we're going to talk about some other misconceptions going forward here, but exactly that. I always talk about the idea of polling 100 people at Walmart. If you polled 100 people at Walmart and you asked them that very question, I'd be willing to bet well over 90% would just assume that the parents in that situation would be able to make decisions. They'd cite the fact that it's a senior in high school. They'd cite the fact that they're on the parents' insurance plan. But they'd be wrong. That they need to receive the information to understand how to make decisions. And again, this is not a sales pitch here. I'm giving information so that people can make informed decisions. But the only way anybody can make an informed decision about anything is if they have full and complete information.
Sure.
And that's what I'm trying to provide here
Is that
today.
the case too? Like when it comes to just making decisions, or even like if you're over 18, if you're a blood relative, they let you into like hospital rooms and stuff like that. Is that or emergency rooms? Let's say, for example, or is that something if you have to have documentation on in some capacity?
Yeah, it's the same thing. I mean, it's up to the person who's admitting it. But again, there are 18-year-olds out there who would not want their parents involved, right? They're emancipated minors. The problem is if somebody's sitting there in a coma, we can't determine which class they fall into. The smaller class of 18-year-olds who would not want their parents to know, or the much larger class of people who would want their parents to know. And it could also be based on facts and circumstances. I mean, an example would be this. If it was a car accident, your decision about letting your parents know might be very different than if it's an accidental overdose, right? I mean,
Sure.
if it's an accidental overdose, maybe you don't want your parents to know that information. So that's why these HIPAA laws exist, because we can't get into the mind of somebody who can't communicate decisions.
Say if somebody's a single person and say if they're not 18, say if they're out of the house and you're like 19, 20, 21, whatever, in your 20s, and you're single and you have this document in place, obviously the people that you have given the rights to make decisions need to know where this document is as well, because if something would happen and you're in a coma, you can't just walk in, can you, and say, hey, I'm given legal rights with we have documentation in place, let me go. You have to probably produce, have to produce something.
You do. And the other thing I would recommend is this, and this does not apply to most 20-year-olds, admittedly, but it applies to most people who are older. What I always tell my clients is have the healthcare power of attorney, on file with your primary care physician. Because that'll be your first point of contact. I mean, again,
that's something you probably never think of. Make sure your physician has it. Your physician has it.
Well, that's right. And that's why I instruct my clients to do it. And again, I would say the average 20-year-old does not have a primary care physician, but the average 40-year-old does. The average 40-year-old probably has a primary care physician. Certainly not all of them, but most do. And the personal example I give is this. I think I've shared this on the radio before. I don't know if I've shared it with you specifically, but I can tell you that, and I have no problem sharing this personal story. I was in an ICU in 2018. I ended up developing pancreatitis on a trip in Pennsylvania. So I'm 1,000 miles away from home in an ICU. And there were two physicians there. And the older physician says to the younger physician, hey, did you check to see if he has a power of attorney in place? The physician's response was, he's in his mid-30s. There's no way he has a power of attorney in place. And actually, I'm like, yeah, I'm an estate planning attorney. I do have that. Here's my primary physician's, because I never lost consciousness, fortunately. Here's my primary care physician's name and number. They had it faxed over in 10 minutes. So I always use that example to show firsthand how easily that information can be obtained if you have it through the right channels. They were able to transmit it 1,000 miles away within a matter of minutes, because I had it on file with my primary care physician. So again, same logic here. I always encourage my clients to do it, but like you said, if you have that 20-year-old who probably doesn't have it, at a minimum, the parents should either know where to access copies of the documents, or better yet, have a copy of the documents themselves. That way, if there is an emergency, they're not fumbling through someone's apartment or someone's bedroom trying to find the documents, and having that electronic copy also helps as well. So A lot of times what I'll do is I'll email my clients the document themselves. That way they can just pull it up if necessary, show it on the phone, do whatever they need to do.
Yeah, that's one of the cases too. I would bet if somebody's in their early 20s, their parents probably, not all cases, but I think their parents probably led them down that path. So they knew, but you get to the mid to upper 20s and they do it on their own. That's where you have to make sure the right people know. Rob, what are some other misconceptions maybe people might have about estate planning?
Well, I think sticking with the power of attorney issue, the fact that spouses don't automatically have that authority. I mean, that's another thing that people will talk about. And again, polling the same 100 people at Walmart, and you ask them, if you have a married couple, husband and wife, husband ends up in a car accident, do you think wife can automatically receive information, make decisions? The answer is no. Now, without a power of attorney, they can't. And that surprises people. They've heard, well, Wisconsin's a marital property state. That may be true. That is true. But that has nothing to do with the ability to share information. It certainly doesn't allow a spouse to bypass HIPAA restrictions in terms of the sharing of that information without the affirmative consent of the person who's in that situation. So again, even married couples need to have these documents in place. Now, what I will say is it's not necessarily the case that you have to nominate your spouse to serve in that position. You can have someone else serve in that position. So again, in that case, if a random person shows up in a hospital bed and they don't know how they got there and they're not able to make decisions, you can't just assume that they would want their spouse to know that information. I mean, some basic facts on marriage. 52% of marriages end in divorce, right? I mean, most marriages don't end in divorce the moment something happens. It's a process. And during that process, you may or may not want your spouse to be the one knowing that information. Or maybe people are together for religious reasons or for their kids, and they still wouldn't want their spouse to know that information. So medical staffs can't just assume that a spouse wants to know that information and have it be shared with their other spouse. That's why we need to have documents in place, such as powers of attorney, to get a written memorialization of what that person's wishes were in that time. I do want this information shared with this person. I want this person being able to make decisions for me. It just can't be assumed based on the fact that they happen to be married.
So obviously, if you end up and you don't have documentation in place, Rob, and you get in a situation where it could go one way or the other. It's one of those things where a life and death type decision needs to be made. If you don't have something in place, how is that decision made? In the hospital room or in the ER or wherever you're at?
So hospitals have ethics boards that make those types of decisions. And then basically that's kind of the short term, the stopgap solution until a guardianship could be acquired. That's a court proceeding where you get authority to serve as someone's guardian to make those types of decisions in the absence of a power of attorney. The problem with those is they're not quick and they're very expensive to obtain. Whereas for a significantly small fraction of that price, you can create powers of attorney to avoid all of this from happening.
Exactly. So you take care of that. And you had mentioned, I think we had talked last week about that. You make an appointment. It doesn't take that long to get something in place so you have it in advance. And kind of talk about what that process is like if somebody wants to get the ball rolling.
Yeah. So step one is just reaching out. And I'll share my phone number here on the air. Again, the office locations, Beaver Dam, Richfield, Port Washington, and West Bend. Port Washington changing to Saukville here in a little bit. The number for any of those locations is exactly the same. It's 262-347-3444. Again, 262-347-3444. I do offer appointments in any of those 4 offices. I do also offer night and weekend appointments if it's more convenient. I can do everything but the final signing through virtual meetings, through telephone calls, Zoom calls, whatever works. And furthermore, I do make house calls as well. I have some clients who have mobility issues. I have some clients who have babysitting issues. They'd rather just plunk their kids in front of a TV during a meeting as opposed to hiring a babysitter. All of those options are available. I want to make it as easy as possible to have that initial consultation, but it starts with a phone call. And again, the phone number is 262-347-3444. My last name is Melick, M-E-L-I-C-K. That's M as in Mary, E-L-I-C-K. 262-347-3444. Always offer free initial consultations and also a 20% discount for WBEV listeners or Daily Dodge viewers.
Is there a typical time that you're busier? Is there time of the year where people are really starting to think about this, where you get like we were just talking, the hire, so you share this is like their huge time with people trying to get their plans in place. Is there a typical time that's busier for you when it comes to putting things like this together?
Yeah, and I'll tell you what I'll do. I'll put you on the spot here a little bit. Why don't you guess? What do you think would be the busiest time of year? And when I tell you the time of year, here's what I'm saying. I'm going to see if you can guess, and if you can guess right, that's great. If you guess wrong, I'm going to tell you what the time of year is, and then you tell me why it's that way. All right, so you have a guess?
Do you think is it this time? Is it at the end of the year?
No, this is actually my lightest time.
Oh, your lightest time. Okay.
Between Thanksgiving and Christmas is actually my lightest time of the year because people are focused on family, family meetings, things like that. Yep. So I will tell you, my busiest time of year is January to February.
Okay, very beginning of the first quarter.
Any guesses as to why?
Is it because people? I don't know. You have to tell me now.
It is a very common New Year's resolution.
Okay. Oh,
People have been putting it off for so long. I mean, people are aware of the common New Year's resolutions. I'm going to lose weight. I'm going to hit the gym. I'm going to give up smoking, whatever the case is. But I have so many clients who say to me, I've been putting this off for so many years. This is my New Year's resolution. I'm going to get it done this year. The other thing is I do have a lot of my clients who will say to me, can I gift an estate plan as a Christmas gift? And they will do that. They will find out what the cost would be to get an estate plan done for their children or other loved ones. And then those children will, after the holidays, give me a call and say, hey, my mom and dad gifted this to me for the holidays. I want to set up an appointment. But by far, the New Year's resolution is the most common one, making January and February my busiest months.
that is a great idea, though. I mean, you talk about it to gift some of your children or somebody younger than you that doesn't have one, even somebody older than you that doesn't have one to put it in place. And do you get a little gift certificate with that?
I'm working on that with the PR department. No, I haven't done that quite yet. But no, and what it is, and you're right, it usually goes down the generations, but it has gone up generations too. I mean, I've had older or adult clients who say, you know what, my parents just haven't done anything yet. I'm just going to pay for it. I'm just going to make sure they get it done, have a meet with you, and get that plan squared away. So, yeah, it's a very common thing. And again, what it is it's something that, to me, that's what a really good gift is. It's someone that's, you're thinking about someone, something that someone may not necessarily get for themselves, but still has value nonetheless. And that's really what the definition of an estate plan is. It may not be the most attractive of gifts. It's not going to be put on Facebook saying, hey, this is what I got for Christmas. But at the same time, it's practical and everybody needs it at some point in time.
Shifting gears a little bit as we talk with Rob Melick from Melick Law, you can give us a call if you have any questions for him on the air at 920-885-4446, or you can feel free to send us a text, 920-887-9595. Do people gift? You mentioned gifting, stuff like that. Gifting even like a jump start to getting like your wills and everything like that done as well, because that's something that people kind of kick the can down the road with as well.
Yeah, it's the same concept. I mean, it's basically just the idea of meeting with me. And again, it's a free initial consultation anyway, so there's no harm lost there by just having that initial meeting. But yeah, it's very common. And one of the greatest compliments I get in my practice is, gee, you did such a good job working with me. I want you to work with my kids. I want you to work with my parents. So it's a great honor. I'm very humbled by people who want to make those recommendations. And then, like I said, I can provide their children or their loved ones with the exact same level of service and make sure they have their plan squared away as well.
Do you get people that come in that want just like one of the different things we have, or do you have people come in and say, I want the full boat, Rob? Come on in. If somebody would say, give me the full boat, what are the things that they should be checking off their list?
Yeah, so the first thing are those powers of attorney.
Yep.
We've talked about healthcare power of attorney, but there's also a financial power of attorney. Obviously, someone who can make financial decisions in the event that someone is alive and incapacitated. So that's kind of the start line. That's something that everyone over the age of 18 should have. The next real decision that people have to make is the difference between wills and trusts. And going back to that topic of misconceptions, a big misconception is that will-based planning is enough. And for most people, will-based planning is not enough because it does not create the guarantee of probate avoidance. And that's really something I've really emphasized both on this show and when I have meetings with clients, the importance of guaranteeing probate avoidance. Not making probate unlikely or even extremely unlikely, making sure that it's not going to happen. And what is probate? Again, it's a word that's commonly associated with estate planning, so let me define it briefly. Probate's the process where a court oversees the administration of an estate. When a estate goes to probate, there are a series of hearings, a series of filings, a series of deadlines, a series of events that occur before assets go from the name of the deceased to the name of the intended beneficiaries. Simply put, at my firm, my goal is to do what I can to guarantee that the estate avoids probate. Why? Why is probate avoidance so important? Boils down to three reasons. First is cost. Average cost to probate an estate, in my experience, is somewhere between $8,000 to $12,000. That's an average. Some are more, some are less. Second is timing. Average length of probate is about 12 to 18 months. Third reason is publicity. The will itself becomes public record when the estate goes to probate. Not only does the will itself become public record, but the amount and the character of the assets also become public record. So again, to summarize three negatives: cost, 8 to 12 grand, timing 12 to 18 months, public record. The trust is the only guaranteed way to avoid probate. In fact, the only way you can avoid probate if you just have a will is if you have less than $50,000 worth of probate assets at the time you pass away. Now, $50,000 is a lot of money. I mean, nobody here would turn down a check for 50 grand. But if we look at the totality of what we own, the first place I go is the real estate. Most people who own their homes, certainly not all, but most, have at least $50,000 worth of equity in the home. I mean, with just natural homeowner appreciation, that's gone up. So you don't have to be exceedingly wealthy. You can be firmly in the middle or even below middle class to have more than $50,000 worth of probate assets. And simply put, if we don't have a trust, we can't guarantee that that estate will avoid probate. By creating a trust, it will, because the trust will never die. And that's the concept that is a little hard to resonate with people. Because, again, a lot of people say, well, why don't I just list beneficiaries on things? And I say, yeah, that's a good idea. But any human beneficiary we list, we have no idea whether they're going to survive you or not. I have 2 children. They're 14 and 12. I hope they survive me. I want them to survive me, but it's not a guarantee. The only thing I can guarantee is that the trust will survive, because the trust will never die. And that's kind of the underpinning of my practice, is creating those guarantees. Now, for some people, the price point for the will makes more sense. Let's go with a will. What I'll also tell you at my firm is I have a lot of people who will create wills in time 1, and as time goes on, they acquire more money, they acquire real estate, they'll create a trust in time 2. What I do for those folks is whatever they paid for the will in time 1, I provide as a credit off the cost of a trust in time 2. That way they're not double paying. Again, I can't tell you my rates will stay the same. They probably won't. But whatever you had as that initial payment gets deferred from the cost of the plan down the road. That way the plan increases with time. And I've had dozens of clients who start with powers of attorney, they create the will, then they go to the trust. Because you may ask, what causes people to go from the power of attorney to the will? And the number one answer should be having children. So that's another area of misconception that we get into. You mentioned you have the 15 and the 14-year-old. I have the 14 and the 12-year-old, okay? We as parents do not have the ability to determine guardianship of our minor children if we pass away unless we have a will or a trust, period. And that's a misconception. A lot of people just assume, well, grandparents will get them or godparents will get them. Or my favorite one is, I have a notarized letter that says my wife and I say that my kids will go to my sister. Completely unenforceable. Not worth the paper it's written on. The only way to determine guardianship of minor children is through a will or a trust. Literally nothing else works. So again, those of you in the listening audience who have children under the age of 18, understand that. Those of you who have grandchildren under the age of 18, convey that to your children, that as long as they're residents of Wisconsin, because just to be clear, laws vary from state to state. What I'm saying here may not apply in other states, but in Wisconsin, if you do not have that memorialized in either a will or a trust, it is worthless. And as a parent, I'd argue that's the most important part of my estate plan. The money is what it is. I want it to go to my kids, but at the end of the day, guardianship decisions are far more important. Who has to raise my kids, particularly if my kids have to go through the devastation of just having lost their parents? Making a decision about who I want raising my kids is the most important thing I can do for my children at that point in time, if my wife and I were to meet our demise before they reach 18.
You mentioned that, we're talking to Rob Melick from Melick Law. You mentioned that, obviously state laws are different. So if somebody has something in place, that is the law, then that can go with you wherever you go, if it's in paper for the most part?
Well, it depends.
Yeah.
If you establish residency in another state, different states.
Okay,
laws are
then you
gonna
have to get it
apply.
all changed.
That's right. Or at least you have to get looked up by an attorney in that state to make sure some portions can be salvaged, some portions cannot. So, again, for those of you listening out here who have out-of-state documents, it's important to have them reviewed by a Wisconsin attorney to make sure that they are either valid or invalid, or maybe some portions are valid, some portions are invalid. But obviously 50 states have 50 different laws, but there are federal laws that supersede and that apply across the country. So it's very important to reach out to an attorney, have those documents reviewed so that the attorney can give you his or her opinion on them.
That's something that you would be able to do for somebody?
Oh, goodness, yes. And I wouldn't even charge for that as well. I would review the documents, because my general rule in my practice, there's some exception, but my general rule is this: I don't charge for advice, I charge for the implementation of the advice. Because you could listen to programs like this, you could go back to all my archive shows, listen to every show I ever do, and you're going to get more information, you're going to get more knowledge, but until we put pen to paper, it's not going to do anything for you. So again, I'm happy to give my prospective clients that information. I'm happy to review documents. And what I do for my clients who come to me who have initial documents, they have documents that maybe they drafted a while ago, they're not sure if they're still valid. I do what I call telling the story of your estate plan, the existing estate plan now. You bring me the documents and I go through them one by one. I say, if you changed nothing, here's how it would go. And what I tell my clients is, stop me when you don't like what you hear. So then I'll flag it. And I'll say, okay, they don't like that provision, and kind of go forward with it, because it could very well be the case that nothing has changed between when you drafted the documents and when we're meeting today. In which case, steady as she goes. Keep the documents. That's very rarely the case. Usually, as time goes on, people have things they want to change, and then we can update them accordingly. But at least that way, we're able to identify which documents need to be updated and which documents can stay as is.
You mentioned a lot of times people are concerned with the price point. Does it vary? Are some people's wills and trusts much more complex than somebody maybe if it is a single person? I mean, is price points different depending on how much work goes into it? How does that work? Because that's a number of people always ask, what's it going to cost to get this all done?
Yeah, not really. I mean, at some level, yes. I mean, depending on how many parcels of real estate they own, but the complexity of the document really doesn't affect. I mean, the example I would give is in the automobile industry. Okay, if I'm buying a car, I don't get charged less for a car if I say I'm going to drive it less. It might depreciate less if I drive it less, but the cost of the car is exactly the same because the cost of the car is based upon the value that it provides. The value of my services, or the cost of my services is based on the value that the services provide. So, again, a will-based plan is going to cost less than a trust-based plan because a will is going to do less for you than a trust-based plan. It's still going to do something, just like powers of attorney. Powers of attorney can do something, but they don't get you all the way there. So, kind of going back to your earlier question of, do I have people who come to me looking for one specific document? The answer is yes, all the time. And then what I do is I say, okay, you may have came here looking for X, but let me explain why Y, Z, and Q are also helpful for you. And then you can decide whether you just want to engage me for X or whether you want to engage me for Y, Z, and Q as well. And again, it's always the client's choice at that point in time. And my philosophy is I'm just going to give information. I don't hit people over the head with things. I say some sharp realities sometimes. I mean, I have to, scare people sometimes with reality and let them make their own decision. But I certainly want to give full and complete information so that people can make fully informed decisions. That's what I'm all about at my firm.
One of the things you mentioned when you were talking, you mentioned that I think you said like when you die, like the document becomes public record. When you say public record, what somebody might say, what does that mean?
Yeah, so most people in the audience are familiar with CCAP.
Yeah,
okay? You go on CCAP, you're hiring a babysitter for your kids. You want to make sure your babysitter doesn't have a criminal record or whatever. So you hop on CCAP and you do it. Well, that's what most people use CCAP for, but CCAP is just the circuit court access portal. It gives access to documents well beyond criminal histories and everything else, such as wills. So if somebody wanted to search that up, they would have the ability to do so. They go down to the local courthouse, pay a couple bucks, get a copy of any public document, certainly have the ability to do that. With a trust, on the other hand, it doesn't go through the courts, so we don't have that access.
So, because a will, for example, because you always remember you're watching the movies and somebody, they go, it's time for the will reading.
That's right.
We have no idea what's in the will, and we find out that, Cousin Eddie got everything left to him. So that's really not the case. If you have a will, people can call up so they kind of know what's in there.
I'll be honest with you. I've been practicing law for 17 years. I have well over 4,000 clients. I've never once read a will.
Yeah.
I have sent letters to beneficiaries, certainly. I have contacted beneficiaries, but I have never once done the Hollywood dramatization of everyone in the room and nobody knows which one. And that's very popular. I mean, you see it in a lot of shows, you see it in a lot of movies, but I can't tell you about the other 49 states' laws, but I can tell you, having practiced in Wisconsin here, I've never once done that. There's no hidden surprises. I mean, as the attorney who drafts the document, I have a duty, if I'm retained by the trustee or the executor, to notify the beneficiaries, and I do that. But it's never as dramatic as you see it on TV.
Yeah, and do you feel like that Hollywood, sometimes people come into you thinking that that's kind of how it works?
Goodness,
yes.
All the time.
I need a will. You're going to say I'm going to leave the house to this daughter, the money to this person, and my car to Aunt Edna, whoever it is, and that's kind of probably some truth to it, but there's probably stretching for dramatic purposes that you see it on in film and entertainment.
And that's the thing. I mean, just again, I would say 95% of my clients who have adult children leave everything to their adult children. Maybe they include a little bit to grandchildren here and there. Maybe they have a little bit of charitable intent. But generally speaking, there's not many surprises. I mean, occasionally there are, and what I encourage my clients to do, and certainly it's their choice, but I encourage my clients to let their beneficiaries know why they're making the choices that they are, particularly if it's for what I would call a good reason. I mean, there are family fallouts and things like that, and I get that, and that's sad, obviously. But what I'm referring to is people who may elect to have a different treatment of children based upon circumstances that they were aware of. The most common example is I did more for child A during child A's lifetime. I gave more to child A. So I'm going to give more to child B at death. Or it's kind of the opposite. Child A is doing really, really well for him or herself, and child B is not doing so well. Child A doesn't need the money. Child B really needs the money, so I'm going to give more to child B. But if you see it in a set of documents and you don't give that explanation, child A may feel slighted by that. But if you explain to child A, look, you're doing pretty well, but your sibling down the road here is not doing so well, so this is why I'm making the decision that I'm making. Again, there's pros and cons to that. I mean, the child A may resent that, and the parent may feel guilty about it or whatever the case is, and rather just say, you know what, they're going to find out at death. And that's fine. again, I just let my clients know that there may be benefits of letting them know ahead of time if there's going to be a disparate treatment of children and the reasons for that disparate
And
treatment.
when you say letting them know, Rob, is it sometimes, or do people have it sometimes written into like the will and such, where they like have child A has been given this, and do they state why, so there's not questions after you have passed? And
Yeah.
they're figuring it out, so it is fully explained. So at least you see on paper kind of what it is. May not agree with it, but at least you know why the decisions were made.
Very infrequently.
Yeah.
It happens occasionally, but most of the time it's just the straight distribution. I tell them to have a conversation. So a couple times we've put in reasons, but generally speaking, we don't. I put it kind of generically for reasons best known to me or to us. Here's how we're doing it. So generally that doesn't happen.
Can people put stipulations in like a will or some sort of a trust saying you get A if this happens here, or if this, not like a Brewster's Millions, if you ever saw that,
Oh, yeah.
that movie with Richard Pryor and John
Candy, of course.
Yeah, but I mean, do people put like provisions in wills triggering different things that you get, or maybe you get at a certain age or things like that?
I say age is by far the most common. You know, I'll always ask that question. You know, at what age do you want your beneficiaries to have unlimited access? I mean, I'll just give my personal example. My two boys, 14 and 12. My trust stipulates that they don't receive the money until they reach the age of 30. So that's a very common way to do it. And some people will tier it. They'll say, okay, you can receive a third at 25, a third at 30, a third at 35, whatever the case is. So age is by far the most common restrictor, but there are other ones, sure. Some of them are a little crazier than others, I'd argue, but it's not my job as the attorney to judge the validity of the exclusions. It's my job to make sure they're legally enforceable and make sure that we can do it. Because some of the, and what I always advise my clients is some of them are illusory. Like, for instance, it'll say something along the lines of, all right, this money can only be used if you graduate from college. Well, what's college? Is that a 2-year degree? Is that a 4-year degree? Like, how do you define it? You know, what if somebody is getting into the trades and they're making more money in the trades than they would with a, you know, useless undergraduate degree? Like, how do you want to distinguish that? So a lot of times if my clients will give me those kind of requests, I'll talk them through it so we can make it as concrete as possible. Because the more black and white there is, the better it is than if there's just many shades of gray here.
Yeah, I know a friend who, a story of a story, she said that she knew somebody who, wealthy relative, a grandmother or grandfather left them money, but it was written in there where you needed to be gainfully employed. You know, you're going to be, you know, inherit some of this money, but you have to have a full. You can't just retire and, you know, travel the world till a certain age in your life,
right? Because
they want to put stipulations on, you know, and things like that. So that is possible.
It's possible, but I guess, you know, my argument would be this. I mean, if somebody, you know, really hits it big in the business world, I mean, take someone like Elon Musk. I mean, goodness gracious. I mean, he's the wealthiest man in the world, and you're really going to put that restriction? Wait till he's 70 before he can use it? I mean, you just don't know. So again, my clients are my bosses. I say that all the time. You are the boss. You tell me what to do. But at the same time, my job as the lawyer is to kind of give you some practical parameters to think about so that you're not inadvertently painting yourself in a corner that you may not necessarily want to be painted into.
We're talking with Rob Melick from Melick Law, and this is the Melick Law Show on the 95.3 WBEV and Daily Dodge TV. You can send us a text, 920-887-9595, or give us a call at 920-885-4446. He's kind of sticking on the wills. Like, what are, like, if somebody comes into you and you have the answers, they just say, I want a basic will, Rob.
Yeah.
What do you consider a basic will?
Yeah, so a basic will would be, first of all, a non-trust.
Yes.
Okay, because that's really the distinction between the will and the trust. So basic will, my next question would be, do you have powers of attorney? And if the answer to that is yes, then my next question is, do you mind if I take a look at them to make sure that they are still legally in preference sufficient? Because depending on where you get them, how they're drafted, sometimes they are, sometimes they aren't. The analogy I always give there is, it's like taking your car for an oil change, right? You go to the oil change place, you say, I want an oil change. They'll put it on a rack, they'll change the oil, but inevitably they're going to come down after the meeting, after they bring the car down, they're going to say, well, now your air filter's a little dirty, you know, you may want to change it. Or I noticed the brake pads are a little worn, we can change these out for this cost. And that's up to the customer, of course, to decide whether to accept or reject the auto mechanic's recommendations. No different in my line of work. I have to or I don't have to, but I feel an ethical obligation to go through my client's documents and say, look, if you have this financial power of attorney, here are the weaknesses with this financial power of attorney. Here's what I can do better for you. Here's what the cost is going to be. And then they can decide either, yep, I'm going to take your recommendations in and I'll have you redraft those documents, or no, I'm going to stick with what I have. So long as they have information to make a fully informed decision, it's their choice at that point in time.
885-4446. If you have any questions, you can give us a call. Here you're talking with Rob Melick. You mentioned this is the time here. So say if somebody's listening right now and they're like, I got to at least get any of these aspects are all done. You mentioned somebody would call your office, and how how far out usually you make appointments with people?
Yeah, it really depends. I mean, usually I'm about a week or so out, but it varies. And I do triage situations. I mean, think about the emergency room in the hospital, right? You go in with a headache and somebody's in there with a gunshot wound. They're going to put the gunshot wound ahead of the guy with the headache, right? So kind of the same thing. And I will get those calls. I'll get calls, hey, my dad's in hospice. He's got 2 weeks. What can you do for me? Well, we're going to do whatever we can for him at that point in time, so long as they have capacity. That's the key thing. They have to have capacity. So that's the typical situation. But again, I work nights, weekends, holidays, whenever I need to be there to get my clients' work done. So long as I can still coach hockey, I'm happy to do that. So again, best way to get a hold of me, any of my 4 office locations, Beaver Dam, West Bend, soon to be Saukville, currently Port Washington or Richfield, 262-347-3444. Again, 262-347-3444. If you want to look me up online, my last name is Melick, M as in Mary, E-L-I-C-K, lawwi.com is my website. If you give my office number a call, again, 262-347-3444, or you can text at that number. I do offer a free initial consultation, and then if you heard about me through WBEV or Daily Dodge, 20% discount off of legal services.
So when somebody gets that first appointment from you, what information should they have? I mean, you're going to ask them, obviously you should probably know, like say if you're doing some stuff where are the children going to go if something happens, what types of information should they have on hand as they begin the process?
Yeah, I mean, that's pretty much the main thing there, making sure that they have that information if they have minor children, and also names, addresses, and phone numbers of anyone who's going to have a role under the plan. Again, we talked about healthcare power of attorney before, nominating the people to make medical decisions. Well, if there's an emergency, the doctor or the hospital needs to call somebody. We need to have up-to-date phone numbers to make sure that they'll be able to contact that person to get as much information as they possibly can as quickly as possible. So again, having that information is very important. So what I always tell my clients is bring any existing documents that you have. That way I can review them for their sufficiency, as well as if you're going to be revising documents or starting from scratch, names, addresses, and phone numbers of anyone who's going to have a role under the plan.
Is that one of those things where you also need to keep those up to date as well? Because people do move around, and I think earlier when you could take your cell phones with you, if you will, a lot of times you change carriers or numbers change and such, where now it's a little bit different where you kind of take your numbers with, but it's important to keep that stuff up to date, isn't it?
Absolutely, especially the phone numbers, because that's the immediate way of getting a hold of somebody. Addresses are more for identification purposes. I don't need to update addresses, but I definitely need to update phone numbers. And again, at my firm, I do not charge for revisions to the documents. So if you draft the initial documents with me, if we're changing the order of people, if we're changing phone numbers, all those changes are done on a complimentary basis when you do your initial estate plan through Melick Law.
And again, you just got to keep that up to date as well. If your parents move, you don't think about it. So just so they know when it's on. If we don't know, then you don't know, and then you just have to keep that stuff going, and it makes a big difference here. Rob, we got about 3 or 4 minutes left. Anything else that people need to know about Melick Law?
Yeah, I think just the main thing is just reach out. I mean, I have so many clients or prospective clients who, they said, I've thought about calling you 3-4 times. I finally got the courage to do so because, my neighbor passed away, or, my aunt passed away, and it was a nightmare going through probate and everything else. So, again, worst case is going to be that the timing is not right. So if you're at all considering this, you have follow-up questions, let's schedule a meeting. Schedule a time to chat. I can walk you through on a personal basis how these documents are going to help you, how you're going to be better off for having them than not having them, how relatively straightforward and easy the process is. I just hope to have the opportunity to earn your ability to do estate planning work for you.
Again, no pressure, and that's why you mentioned you offer the no fee consultation, so people can come in and get a feel for what they're looking for, and then get an idea of what it's going to take to get that done.
That's exactly right. I may apply pressure on the field as a football coach or on the ice as a hockey coach, but as an estate planning attorney, I'm about as laid back as you're going to find. So.
And again, the initial consultations, just figure out what's going on and figure out what you need, and you'll take care of them in a timely basis.
Absolutely.
Again, how can people contact you?
Yeah, so any of my 4 office locations, by text or by call, 24/7 availability, 262-347-3444. Again, 262-347-3444.
You had mentioned you're in the full boat of hockey season. You're saying you had 4 games yesterday?
Yep. Each of my sons had 2 games. I have a peewee and a bantam, so 2 games each, went 2-2. So it was a okay weekend, but it was a lot of fun. So between them, I'm just doing some quick math in my head. 6 goals in the 4 games. So
Nice.
they did pretty well.
Hockey season is fun, and again, as we head down the home stretch of 2024, if you're looking to maybe jumpstart a child or something on this, if they check out melicklawwi.com, spell Melick again for people.
Sure, it's M as in Mary, ELICK.
Because you have a great website, talking about everything. They have a frequently asked questions and about you. If people want to learn a little bit more, testimonials, and they can learn about what the process is like at Melick Law. Again, that's melicklawwi.com. Rob, appreciate you joining us here today.
Thanks for having me. Have a great day.
It is coming up on 11:54 here on 95.3 WBEV and DailyDodge.com. Have a great day, everybody.